That's
unavoidable.
Go ahead.
I'm sorry. That's unavoidable. In the civil context, at least at common law, I believe that restitution was not an equity, was it? Claim, or was it a common law jury claim?
So, Justice Sotomayor, this depends a little bit on shifting meanings of the word restitution, and I agree with petitioner who points this out in her brief, or his brief, counsel's brief. Restitution is a word for an equitable remedy that I think would fall on the Beacon Theater's bench trial side of the line when you're talking about restoring something taken. And some of the remedies under restitution take that form. So if someone steals your car, restitution might have to be to return the car. I think that actually would fall on the Beacon Theater's line of you don't need a jury trial.
But this is different. This is paying a monetary
some of the forms of restitution, the majority in the statute here, are really traditional damages.
So
forms.
really, jury trials would have been required in the common law. If we required them in the criminal context because it's a substitution for civil, wouldn't be the end of the world, Counselor. It would just be avoiding taking away a right to a jury trial.
I don't think it would be end of the world as a practical matter. It would mean the entire statutory scheme has been unconstitutional for decades because they haven't been provided jury trials. I don't think practically it couldn't be implemented. But as I said, I think the Sixth Amendment problem is much clearer.
Well, this would be a new rule because we pretty much have established precedent to the contrary. Thank you.
I do think there would be an argument under the Seventh Amendment that this could survive under the reasoning of.
So you're not buying their footnote 3 in the government's brief then on the Sixth Amendment? Yeah. Where they,
the government, I think, if I'm remembering the footnote, rehashed the Court of Appeals views.
Correct.
The judgment of conviction authorizes unlimited restitution. That is just not true. There has to be a finding of particular items of loss. That is a factual finding that you can't, that without which no restitution is authorized. So it's just not correct. I don't see how a lot of Court of Appeals have adopted that view, but I don't think it is correct.